Deputy Breck, I am requesting written documentation. I am not resisting. I am standing still.
Get your folder off my counter and go stand over there until I decide whether you belong in this building. Nobody asked his name. Nobody had to. The man in the brown uniform said it the way people say things they have repeated so many times they no longer hear themselves. Flat, automatic, as certain as gravity. He pointed toward a wooden bench against the far wall, the kind of bench that exists in courthouses and bus stations and other places where people are made to wait as a demonstration of who holds the clock. Simone Voss did not move immediately. She stood at the security threshold of the Caldwell County Superior Courthouse at 7:15 a.m. on a Tuesday in early April, an accordion folder pressed flat against her forearm, and she took one measured breath. The lobby smelled of industrial floor cleaner and old paper. Fluorescent lighting buzzed faintly overhead. One fixture above the deputy's station flickering at irregular intervals. A small mechanical complaint that had apparently gone unreported long enough to become part of the furniture. The accordion folder stayed where it was, against her arm, not on his counter. Deputy Floyd Breck was a large man in the particular way that institutional authority tends to produce large men. Not simply in frame, but in presence, in the practiced expansion of space that comes from years of being obeyed without question. He wore his badge on the left breast of a uniform that fit poorly at the shoulders, and he had the expression of someone whose patience had run out sometime in the previous decade and had not been replenished since. He looked at Simone the way he had apparently looked at a great many people who arrived at 7:15 a.m. with accordion folders, with the settled certainty that they were going to be a problem. "Ma'am," he put weight on the word, "I said stand over there." Simone reached into the front pocket of the accordion folder. Not rushed, not slow. The motion was practiced in a way that had nothing theatrical about it, the way someone reaches for a document they have retrieved 100 times before. She produced a single laminated card, approximately the size of a standard index card, and held it so the text faced outward. "Deputy," she said, keeping her voice at the level of ordinary conversation, "I want to make sure we're starting from the same page. Caldwell County Administrative Order 2019-04, Section 3, Paragraph 1. She read from the laminated card without looking down at it, which meant she had read it enough times to carry the words without effort. Quote, "Public access to all courthouse floors shall be permitted during posted business hours for individuals with documented case interest or lawful purpose, without requirement of escort except in restricted areas designated by posted signage." End quote. She paused for precisely the amount of time required to let the words settle. "I have documented case interest. I would like to proceed." Breck's jaw moved. Not quite a clench, more the small, muscular adjustment of a man recalculating without wanting anyone to notice he is recalculating. He looked at the laminated card. He looked at Simone. He looked at the folder. "Where'd you get that?" "The courthouse website," she said. "It's public." The fluorescent light above his station flickered again. Breck reached across the counter and pressed the call button on the desk phone without looking away from her. A second officer appeared from the corridor behind the security station. Younger, uncertain in that specific way of someone who has just walked into a situation they do not fully understand and is trying to read which direction it is heading. Breck told the younger officer, without taking his eyes off Simone, to get the list. The younger officer disappeared. Breck straightened. He put both hands on the counter. He said in the same flat tone as before, "You need to be on the access list for the second floor. Those are the rules. New rules." Simone asked calmly if those new rules were in writing. The younger officer came back with a clipboard. Breck scanned it. He ran his finger down the page once, then again. His finger stopped. He said nothing for a moment. Then he lifted his hand from the page. "Voss," he said. Not a greeting, more like a finding, a piece of information he had located and was not sure he liked the shape of. "That's correct," she said. Another pause. The flickering light held steady for 3 full seconds, then resumed its irregular pulse. Somewhere deeper in the building, a door opened and closed. Footsteps on tile. The ordinary sounds of a courthouse coming to life at the start of a working day. Breck nodded once, a minimal, reluctant motion, and said, "Second floor, filing window. You wait in the public corridor. You do not go past the frosted glass door without an escort. You understand me?" "I understand you," she said. She did not thank him. She did not smile. She walked toward the elevator, accordion folder back under her arm, and she pressed the call button. The elevator came. She stepped inside. The doors closed. Behind her, the light above Breck's station flickered once more, then held, steady, cold, and utterly indifferent. What nobody in that lobby could have known, not Breck with his clipboard, not the younger officer still holding the door behind the security station, not the single other visitor sitting on the wooden bench near the window, pretending not to have watched the entire exchange, was what Simone Voss carried inside that accordion folder. Not just the laminated card, not just the case papers for her brother's hearing, something else, something she had been building, page by careful page, for 11 months. The kind of documentation that does not announce itself, the kind that simply accumulates and waits, and one morning sits at the threshold of a courthouse and asks to be let in. She already was. If this story has you leaning forward already, hit subscribe and turn on notifications. What happens in this courthouse over the next few weeks will not let you look away. Simone had been coming to Caldwell County Superior Courthouse for 4 months before the morning with Breck and the laminated card. She had come quietly, consistently, and always at the same time, 7:15 a.m., just before the security shift change, when the lobby was transitioning and the log was being handed from one officer to the next, and nobody was paying close attention to anyone's name. She kept a small spiral notebook in the outer pocket of her shoulder bag. Not in the accordion folder, that was for case documents, filed by date with color-coded tabs she had chosen at a dollar store in a town 40 minutes away so nobody local would recognize the pattern. The notebook was ordinary, the kind sold in bulk near school supplies. She had 3 of them, identical. She wrote in the first one dated entries, the date at the top, then the weather, then the full names or partial names of every person she observed at the security station, then any procedural deviation from the posted policy she could document. She did not write interpretations. She wrote only what she saw, what was said, and when. The habit had started years before Caldwell County, before the accordion folder, before the laminated card, but the specifics of why and where and under whose direction were not visible in the notebook itself. If anyone had picked it up and read it, they would have found a record so meticulous it looked almost obsessive, yet so stripped of opinion it read more like a log than a journal. The date, the weather, the name, the deviation, if any, that was all. The notebook said nothing about Simone herself. That was deliberate. Her brother, Darnell Voss, was 38 years old and had been waiting for the resolution of a property boundary dispute for 2 years and 4 months by the time Simone arrived in Caldwell County. The dispute was not complicated on its face. A survey discrepancy involving the eastern line of a parcel their mother had owned, and a neighboring landowner who had expanded a fence by 19 feet during the months immediately following their mother's death. The case had been assigned to Judge Carla Weiss in the Caldwell County Superior Court. It had been continued 5 times. The reasons on record range from scheduling conflicts to administrative delays to one entry that read only, "Docket Management." Each continuance had cost Darnell another payment period on property he was trying to settle before a tax lien attached. The math was not abstract. He was running out of time. Simone had reviewed the case file before she ever entered the courthouse. That review had taken 2 weeks. She had read the original survey, the neighbor's counter-survey, the 3 procedural motions Darnell's appointed public advocate had filed, and the 2 that had been denied without a written ruling. She had also read the continuation orders, not for what they said, but for what they didn't say, for the missing procedural reasoning that should have appeared under Georgia Rule of Uniform Superior Court Practice Rule 10.1, which required written findings for continuances beyond the initial one in contested civil matters. The rulings were thin, consistently thin, and they all bore the same signature. Simone did not share these observations with Darnell. She told him she was there to help navigate the paperwork. He knew her well enough not to ask further questions. The second morning she came to the courthouse, she noticed the differential. It was not dramatic. It was not the kind of thing that appears in a single incident report or triggers a formal complaint on its own. It was the kind of thing that only becomes visible when you are looking for it and have decided to write it down every time you see it. A white man in a jacket and tie walked through security at 7:22 a.m. with a briefcase in each hand. Breck nodded him through without touching the bags. 3 minutes later, a black woman in her 60s with a cloth tote bag was asked to place the bag on the conveyor, remove her jacket, and stand with her arms out for a wanding. The wand showed nothing. The woman thanked him. Breck did not respond. Simone wrote it down. Date, time, description, no interpretation. She was not the first person to write things down in this courthouse. She suspected she would be the last. The question was what got done with the notebook afterward, and that, like most things that actually mattered, depended entirely on what else was in the accordion folder. The filing window on the second floor was managed by Ivory Rudd, the courthouse's court administrator. Ivory Rudd was a compact woman in her late 40s who wore reading glasses on a beaded chain and had the manner of someone who had been doing her job for long enough that the job had become an extension of her personality rather than a separate activity. She was not rude exactly. She was efficient in a way that looked like courtesy without actually being it. The kind of efficiency that processes people through a system without ever quite seeing them as people. She knew where every form was. She knew which dockets were active and which were stalled. She knew the schedule 3 weeks out, and she controlled access to that schedule with the quiet authority of someone who understands that information is a form of power, and that power, distributed carefully, remains concentrated. Simone had been to the filing window 5 times before the morning that became significant. 4 of those times, she had been told her documents were received and would be processed within the standard period. The 5th time, she had arrived to check on a notice of hearing for Darnell's case, a scheduling notice that should have been issued 10 days prior following the submission of a renewed motion. And Rudd had told her, without looking up from her desk, that no such notice had been generated because the motion had been routed to the inactive review queue pending a docket assignment clarification. Simone had asked, in the same measured voice she used at the security desk, what a docket assignment clarification was, and which section of the Uniform Superior Court rules authorized the routing of active motions to an inactive queue. Rudd had looked up then. She had put her glasses on. She had studied Simone for a moment with the particular focus of someone reassessing a situation they had believed to be simple. Then she had said that it was a standard administrative procedure and that Simone would receive notice when the routing was resolved. Simone had asked for the timeline in writing. Rudd had said she would need to submit a formal inquiry form. Simone had asked for the form. Rudd had said the forms were temporarily out of stock. Simone wrote it down. Date, time, every sentence attributed, no interpretation. That was the 3rd time in 4 months. 3rd scheduling notice. Lost, rerouted, or simply not generated. Each instance had cost Darnell another postponement. The first time might have been an error. The second time might have been understaffing. By the 3rd time, Simone had long since stopped treating it as an accident. What she had not yet done, not visibly, not in a way anyone inside that courthouse could observe, was act on what she had accumulated. She sat in the public gallery. She filled out the forms. She asked the questions. She wrote down the answers. She came back at 7:15 a.m. every time, and she placed the accordion folder flat against her forearm, and she let Breck tell her where to go. Because patience, deployed correctly, is not passivity. It is the act of building something the other side doesn't know is being built. The gallery in Judge Carla Weiss's courtroom was a study in institutional stillness. Wooden pews that creaked whenever anyone shifted weight, a low railing separating observers from counsel tables, and fluorescent lighting that cast everything in the same flat pallor as the lobby downstairs. Weiss herself was the kind of judge who had been powerful long enough to stop performing authority and simply inhabit it. She was white, in her late 50s, with silver blonde hair worn close to her head, and a bench manner that could be read two ways, depending on where you were sitting. If you were at the counsel table on the correct side of her mood, she was crisp and efficient. If you were on the other side, or in the public gallery with a notebook, or at the filing window asking for documents that should have been automatic, she was something else. On a Wednesday morning in mid-March, Simone sat in the third row of the public gallery and watched Weiss preside over a hearing she had not been told was scheduled. She had learned about it accidentally. Rudd's scheduling notice had again failed to materialize, but a posting on the courthouse bulletin board near the elevator, updated irregularly and without a consistent signature, had listed it under a case number Simone recognized. She had written the case number down weeks earlier in a different section of the notebook, under a heading that said only, Associated. The hearing was a motion to compel. Darnell's public advocate attempting to get the neighbors' expanded survey documentation admitted into the record. The advocate was a young man named Caleb, assigned to Darnell's case 8 months into the delay, who had the focused competence of someone who knew what should happen, but was slowly learning the specific geography of what did happen in this particular courtroom. He stood at the counsel table and stated the basis for his motion clearly, citing the relevant evidentiary rule. Weiss let him speak for approximately 2 minutes. Then she said, without consulting any document, and in the tone of someone already moving to the next item, that the motion was denied on the grounds that the filing date of the supporting exhibit did not comply with the advance submission requirement. Caleb paused. He looked at his file. He said respectfully that the exhibit had been submitted 14 days prior to the hearing date, which met the 10-day requirement under Local Rule 4.3. Weiss said the requirement was 15 days. Caleb said he had a copy of the local rule that specified 10 days. Weiss said he was reading an outdated version. There was a silence of the kind that settles in a courtroom when someone has just been told something that is either true and they didn't know it, or false and everyone present can sense it. Caleb looked at his copy. He looked at the date printed at the top, the version identifier, which a person who was paying attention would have known to check. He was paying attention. The date was current, but he was 26 years old in Judge Weiss's courtroom, and the mathematics of that room did not favor him at that moment, and he sat down. Simone, from the third row, wrote down the time, 10:48 a.m. She wrote down the rule number Caleb had cited. She wrote down what Weiss had said. She wrote, in parentheses, the version date on the copy Caleb had been holding, which she had been close enough to read from her row. She did not stand. She did not raise her hand. She waited, and she wrote, and the gallery creaked whenever someone shifted. Near the end of the hearing, as the gallery was beginning to clear, a clerk leaned over to Simone and said, quietly, that she was going to need to spell her last name for the sign-in sheet. The clerk had pronounced it Voss. The correct pronunciation was straightforward, one syllable, rhymed with boss. Simone spelled it without comment. The clerk thanked her and moved on. It was the second time in 3 visits that someone had mispronounced it. Not maliciously, perhaps, but consistently. And in a courthouse, consistent errors have a way of compounding. Downstairs in the lobby, Simone passed the bulletin board on her way to the door. Tucked in the lower right corner, beneath a notice about parking permit renewals, was a county newsletter, the kind produced monthly by the local Chamber of Commerce and distributed to government offices as a matter of civic habit. She stopped. On the front page was a photograph, Judge Carla Weiss and County Commissioner Raymond Chalk at a spring fundraiser dinner, both in formal dress, both laughing at something out of frame. The caption identified the event as the annual Caldwell County Development Gala. The date at the top of the newsletter was 3 weeks prior. The date of Darnell's most recent continuance, the one entered without explanation into the docket, was 2 days after that dinner. Simone looked at the photograph for a long moment. She did not take the newsletter. She read the caption twice. She wrote the date of the newsletter, the date of the fundraiser, and the date of the continuance in the notebook, on a new page, with a line connecting all three. Then she walked outside, into the April air, and got in her car. She sat without starting the engine for 4 minutes. She opened the notebook to a fresh page. She wrote one sentence. She closed the notebook and put the car in reverse. What she wrote was not visible to anyone else. That, too, was deliberate. The next morning, Carter Pell found her in the second-floor corridor. Pell was the assistant district attorney assigned to several of the contested matters on Weiss's docket, and he had the manner of someone who had been the smartest person in most of the rooms he had occupied over the past decade, and had allowed that history to shape his interaction style in ways he likely considered confidence, but that read, to a careful observer, as something closer to contempt dressed in the clothes of procedure. He was tall, wore well-pressed suits, and spoke in the cadence of someone who had been trained to build legal arguments and now applied that architecture to ordinary conversations, whether or not the other person had consented to be argued at. He approached Simone at the corridor outside the filing window and said that he understood she had been accompanying a civil litigant to hearings in Judge Weiss's court. Simone confirmed this. He said that he wanted to make sure she understood the scope of permissible gallery observation under Georgia law, specifically regarding the prohibition on unauthorized practice of law under Georgia Code Section 15-19-51, which restricted non-attorneys from representing parties in legal proceedings. Simone said she understood the statute. Pell smiled, not warmly, and said that he wanted to make sure because he had observed that she had been present in the gallery during hearings, and he wanted to ensure there was no confusion about her role. She asked him which specific behavior he was referring to. He said he was speaking generally. She said she was happy to discuss specific conduct if he could identify it, but that gallery attendance by a member of the public with documented case interest was explicitly authorized under the courthouse access policy, and that she had not represented Darnell Voss in any capacity in any proceeding. She said it without heat. She said it the way someone states a coordinate on a map, not to argue, but to mark a position. Pell looked at her for a moment. He said he was simply making sure she was aware. She said she appreciated the clarification. He asked if she was an attorney. She said she was not going to answer questions about herself in a hallway without knowing the purpose of the inquiry. He said he was asking informally. She said informal questions were still questions, and she preferred to keep their interaction within the scope of documented court business. He said, with a smile again, that she seemed to know a lot about procedure for someone without a legal background. She said she had read the rules. He held her gaze for a beat longer than the exchange required. Then he said he supposed that was fine and walked away in the direction of the stairwell. Simone turned back to the filing window. She did not write this exchange down immediately. There was a small line forming behind her, and she needed both hands for the document she was retrieving. But when she got back to her car, she opened the notebook to the current date and wrote every word she could recall, in sequence, with the time and location at the top. She wrote Pell's name. She wrote the statute he had cited, and she noted in brackets at the end that he had not produced the text of the rule in writing, and had declined to specify the conduct he was concerned about. She underlined, "declined to specify." Then she put the notebook away and took out the accordion folder and opened the section tabbed with an orange divider and added a single index card to the back of the stack. The index card had the date at the top. Below it, one word, Pell. That was the end of the first month. The second month moved at a different pace. Rudd routed another filing, Darnell's supplemental survey documentation, submitted through the proper channel with a clerk's receipt stamp, to what she again described as a docket clarification queue. This time, Simone requested the clarification's basis in writing within 24 hours. Rudd told her the request would need to go through a formal inquiry form. Simone said she was resubmitting the request for the form itself, in writing, under Georgia Code Section 50-18-70, the State Open Records Act, which required government agencies to provide public records within 3 business days of a written request. Rudd looked at her over the reading glasses. Simone smiled just briefly, the smile of someone who is not asking for anything that is not already owed, and said she would wait. The form appeared the following morning. Small victories in a bureaucratic skirmish are rarely dramatic. They do not announce themselves. They arrive in the form of a manila envelope slid under a door, or a clerk's reluctant acknowledgement that, yes, the document you requested is available, and no, there will be no explanation for why it took this long. Simone received the form. She completed it. She filed it with the required documentation. She received a formal acknowledgement 5 days later, stamped and signed, that her records request had been received and was being processed. No resolution, no explanation. Just the stamp and the date, which was its own kind of answer, a confirmation that the system had acknowledged her existence, which meant the system's conduct toward her was now on record. Meanwhile, Raymond Chalk appeared, not at the courthouse directly, not in a way that could be easily logged. He appeared the way that county commissioners in small Georgia jurisdictions tend to appear when something has come to their attention. At a lunch table in the courthouse annex cafeteria on the 3rd floor, which was technically a public space, but which operated in practice as a gathering place for people who worked in the building and wanted to speak without being overheard by visitors. He was there on a Tuesday afternoon when Simone happened to be on the 3rd floor, returning a completed form to the administrative offices, and she did not stop or slow her pace, but she noted the table and its occupants with the lateral attention of someone who has trained that reflex. Chalk was a broad-shouldered man in his 60s, with the unhurried manner of someone who had been elected to public office multiple times and had concluded that the process of being re-elected was primarily a social exercise. He wore a county lapel pin. He was speaking to someone whose back was to Simone as she passed. She caught only the profile, but the set of the shoulders and the slight tilt of the head suggested the conversation was not casual. She caught 3 words as she passed the table. She did not stop to confirm them. She wrote them down in the elevator on the way back to the 2nd floor. 3 words, the table number, the time. No interpretation, no assumption. 3 words, the Voss situation. She did not know whether those words referred to Darnell's property case, to her own presence in the courthouse, or to something else entirely. She did not know who had been sitting with their back to her. She knew only what she had heard, and she wrote it down, and she let it sit in the notebook with everything else. Each entry a coordinate in a map she was building, one data point at a time. The case for Darnell's 4th hearing was scheduled. Through what appeared to be a legitimate scheduling notice, the first one that had arrived on time in 3 cycles, for a Thursday morning in the 1st week of April. The hearing was a motion for emergency relief. Darnell's advocate, Caleb, had filed under Georgia Code Section 9-11-65, requesting a temporary restraining order against any further expansion of the neighboring fence line during the pendency of the case. The fence had moved again, 6 additional feet, confirmed by Darnell's independent survey over the previous winter. The motion was time-sensitive because the property tax assessment period was approaching, and the boundary dispute was creating uncertainty in the assessment, which was creating uncertainty in the lien calculation, which was creating a financial exposure that Darnell could not sustain. Simone arrived at 7:15 a.m. She logged her arrival in the notebook: date, weather, the name of the officer at the security desk, who was not Breck that morning but a younger man she had not seen before, who processed her entry without incident. She took the elevator to the second floor. She confirmed with the clerk that the hearing was on the docket for 10 a.m. in courtroom 3. She went to the third-floor restroom, which she had established in her second visit as a location where she could review documents without being observed or questioned, and she spent 20 minutes going through the relevant materials in the accordion folder before descending to the gallery. She was seated in the second row by 9:50 a.m. Caleb arrived at 9:55. He looked tired in the way that court-appointed advocates consistently look tired, not from any single night, but from the accumulating weight of carrying too many cases with too few resources while trying to genuinely help each one. He saw Simone and nodded. He did not ask why she was there. He had stopped asking that after the second hearing. Judge Weiss entered at 10:08 a.m. She did not apologize for the 8 minutes. She sat, adjusted her robe, reviewed something on the bench that Simone could not see, and called the case. Her tone was the same as always, efficient, close to impatient, as though the proceedings were an inconvenience occurring in the path of something more important she was trying to get to. Caleb began his argument for the emergency restraining order. He cited the survey documentation. He cited the timeline of the boundary encroachment. He cited the financial exposure to the tax assessment period. He was clear. He was organized. He had done the work. He had been speaking for approximately 4 minutes when Weiss said, without looking up from the bench, "You are not counsel of record. Who authorized this representation?" Caleb said he was court-appointed under the Civil Legal Services Program, as documented in the file. Weiss said she was not looking at his appointment documentation. A pause. Caleb reached for his file and produced the appointment order. He offered it to the clerk for the bench. Weiss glanced at it. She set it aside. She said in a tone that was not quite dismissive, but occupied the territory adjacent to it, "And who is seated in the second row?" Caleb said she was an observer with case interest, a family member of the petitioner. Weiss said she was not aware the gallery was open to case participants. Simone, from the second row, said quietly and without standing, "The gallery is a public space under Administrative Order 2019-04, Your Honor. I'm not a case participant. I'm observing." It was the first time she had spoken inside the courtroom. She had chosen the moment carefully, not to confront, but to document. Because courtroom proceedings were on the record, and anything said inside them was preserved in the transcript, and a transcript was a document, and documents were what the accordion folder was for. Weiss looked at her. She did not look at her the way a judge looks at a gallery member who has made a procedural point. She looked at her the way someone looks at a problem they had hoped would resolve itself, and have just been informed will not. "I see," Weiss said, and returned to Caleb without addressing the substance of what Simone had said. She resumed reviewing the file. Then she said, "Mr. Caleb, your motion is denied on timeliness grounds. The affidavit supporting the survey was not submitted within the required advance period." Caleb checked his file. He had submitted the affidavit 11 days prior to the hearing. He said so. Weiss said the required period was 15 days. Caleb said his copy of Local Rule 4.3 specified 10 days. He had a current copy in his file. Weiss said, "Your copy may be outdated." She moved to the next item on the docket. Caleb did not argue further. He was experienced enough to know that arguing a point directly with Judge Weiss in her courtroom, without a written order in hand, without time to research and brief the question, was a path that went nowhere. He sat down. He made a note. He would brief it for appeal if the case went that far. Simone, in the second row, wrote down 10:23 a.m. She wrote the rule number. She wrote Weiss's statement verbatim, as close as she could reconstruct. She wrote, Local Rule 4.3, version date TBC, in the margin. She circled it. She would check it in the law library on the ground floor before she left the building. The check took 11 minutes. The current version of Local Rule 4.3, confirmed in the print copy maintained in the courthouse law library and dated current by the court administrator's seal on the title page, specified 10 days, not 15, 10. Simone photographed the title page with her phone. She photographed the relevant rule. She filed both photos under a new section in the accordion folder, a section tabbed in red, which she had not used before that day. Red was for primary evidentiary material. She had been saving the red section. She had known, since approximately the third week, that she would eventually need it. The hearing ended at 10:31 a.m. Simone stayed in the gallery until the room had cleared, a habit from her first visit, grounded in the understanding that what happens in a courtroom after the formal session sometimes tells you more than what happened during it. She watched the clerk annotate the docket sheet. She watched Caleb pack his files in silence, the focused quiet of someone running through what he could have done differently and arriving at the correct answer that there was nothing. She watched Weiss exit through the door behind the bench without acknowledging the remaining occupants of the room. Then she went to the law library. When she emerged from the library 11 minutes later with the photographed documentation secured in the accordion folder, she ran the timeline in her head. 4 months. 4 continued or denied hearings. 3 scheduling notices either late, lost, or rerouted. 2 rule citations from the bench that did not match the written rule text. 1 conversation with Pell in the hallway. 1 county newsletter photograph. 3 words overheard at a lunch table. 1 notebook, nearly full. She took the elevator to the second floor to return a library call slip to the appropriate desk, which required passing the filing window. Ivory Rudd was not at the window. A junior clerk was covering, which was relatively unusual at that hour. Simone noted the clerk's name from the name placard and noted the time. She handed back the call slip. She asked, while she was there, whether there had been any update on her open records request from the previous month. The clerk checked the log. The clerk said the request was still showing as processing. Simone thanked her. She wrote it down. She was at the elevator when Carter Pell appeared from the stairwell door. He did not look surprised to see her, which meant he had either come from the hearing or had been told she was in the building. She could not determine which from the expression. He was carrying a thin file, and he held it in front of him in the way that lawyers sometimes carry files in corridors, not for immediate use, but as a kind of prop, a signal of official purpose. He said, "Good morning." She returned the greeting. He said he had observed the hearing and wanted to follow up on something. She said she was happy to have a conversation if he could identify the purpose. He said he was concerned that her presence in the gallery might be creating confusion about her role in the proceedings, and that he wanted to make sure there was no misunderstanding about the limits of what gallery observers could do under Georgia bar rules. She said she had not done anything in the gallery other than observe and take notes, which were permitted activities under the courthouse access policy and the First Amendment's protection of court attendance. He said she had spoken from the gallery during the hearing. She said she had made one statement in response to a direct question from the bench, identifying herself as a gallery observer, which was not a legal representation. He said the line between observation and participation could be difficult to draw. She said she agreed that lines could sometimes be difficult to draw, which was why they were best evaluated against specific, documented conduct rather than general concern. He was quiet for a moment. He shifted the file from his right hand to his left. He said, and this time the procedural courtesy had thinned enough to show what was underneath it, that he intended to file a motion to clarify the scope of permissible gallery conduct in ongoing civil matters before Judge Weiss, and that he wanted her to know this was forthcoming. She said she understood. He said he hoped she understood it was nothing personal. She said procedure rarely was. He walked past her toward the stairwell. She watched him go, and she noted the time, and she noted what he was carrying, and she wrote it down when she got to the landing. The emergency hearing that had just concluded, and the motion that Pell had just telegraphed, were two separate instruments playing toward the same outcome. She had been watching for this phase. The shift from passive obstruction to active countermeasure meant that her presence had stopped being an inconvenience and had started being a threat, which meant the accumulation she had been building was becoming visible to people who had reason to want it invisible. That was a significant change, not a comfortable one, but significant. She did not go to her car. She went to the ground floor and sat on a bench near the main entrance. Not the bench Breck had pointed her toward on her first day, but one near the window that got the morning light and was close enough to the bulletin board to read the new postings without standing. She opened the accordion folder and reviewed the red-tabbed section. Then she made a decision. She did not make it dramatically. She made it the way most important decisions are actually made, quietly, seated, with adequate documentation on hand, and a clear understanding of the next procedural step. She took out her phone and sent a message. It was brief. She wrote, "Motion coming. Pell. Expect fast-track request." She sent it to a contact stored not by name, but by a three-letter identifier. She had been using this method of contact for 11 months. The contact had never been saved under a full name in her phone. That, too, was deliberate. She received a response in under 4 minutes. 2 words. Noted. Continue. She put the phone away. She picked up the accordion folder. She walked out of the courthouse into the April morning, and the sun was fully up now, and the parking lot smelled of cut grass and diesel from a maintenance vehicle working near the far fence line. And she got in her car, and she drove. She had exactly 48 hours before Pell's motion was heard. What the audience could not yet know, what nobody in that courthouse had been able to determine in 4 months of observation and suspicion, was where she was driving. Not to a law office, not to a family member's house, not to any address in Caldwell County or the 3 counties immediately adjacent to it. She drove north on the state highway for approximately 30 minutes, then turned onto an access road marked only with a numbered rural box and a posted sign for a state agency that had nothing visibly to do with courts or filings or property disputes. She parked. She went inside. She was there for 1 hour and 43 minutes. She came back to her car with a different section of the accordion folder open on the passenger seat. Not the red section, but a section tabbed in deep blue that she had kept closed since the first week of the investigation. The blue section was the section that said who she was and what she was actually doing in Caldwell County. It held credentials that nobody in that courthouse had seen. It held authorizations that nobody had been told to expect. It held, among other things, 11 months of filed reports, cross-referenced incident logs, and a case number that appeared nowhere in the Caldwell County docket system, because it was not Caldwell County's case at all. She did not open it. She set it on the seat. She started the car. She drove back. The accordion folder rode on the seat beside her in the afternoon sun, the red section facing out, the blue section underneath, both exactly where they had been for 11 months. 48 hours. Pell's motion was filed the following morning. Simone found out about it the way she had found out about the earlier hearing, not through the scheduling notice she had requested, but through the courthouse bulletin board, updated in the early morning before anyone she recognized was at the security desk. The motion was styled as a petition for clarification of gallery participant conduct standards in civil proceedings before the Caldwell County Superior Court, and it had been assigned by a docketing decision that Simone noted in her notebook without editorial comment, directly to Judge Carla Weiss. The emergency hearing on the petition was set for 48 hours from filing. That was unusually fast. Under the standard Caldwell County Superior Court scheduling practice, motions for procedural clarification typically waited 3 to 5 business days for a hearing date. The 48-hour assignment required a manual override of the standard queue, a queue that was managed by Ivory Rudd's office. Simone noted the docket assignment timeline. She noted the name of the docketing clerk who had signed the scheduling order, which appeared at the bottom of the notice in small print. She wrote it down. She drew a small bracket connecting it to Rudd's name from 2 entries earlier in the notebook. No interpretation, just the bracket. She spent the first day of the 48-hour period doing 2 things. The first was reviewing Pell's motion in the law library, which had a public document terminal where filed motions could be accessed. The motion was, as he had telegraphed it, legally aggressive and procedurally thin. It cited OCGA Section 15-19-51, the unauthorized practice of law statute, and argued that the presence of a lay advocate in ongoing proceedings before the court created an ambiguity that warranted judicial clarification of permissible conduct. It did not cite any specific conduct by Simone. It did not identify any specific instance in which she had acted as legal counsel. It referred throughout to the individual in question rather than her name. She read it twice. She made 2 margin notes in her own copy, one noting that the motion used the phrase legal representation in a way that conflated observation with advocacy, and one noting that the cited statute's definitions section explicitly excluded family members accompanying civil litigants from its scope under subsection C, paragraph 2. She did not mark these notes for argument. She marked them for the record. The second thing she did that day was far simpler and far more consequential. She went to the filing window, waited in the queue, and asked Rudd, who had returned to her station from whatever absence the previous day's junior clerk had been covering, for a copy of the full docket history for Darnell's case, including all routing notations. Rudd looked up from her desk. Simone said she was submitting the request under the Georgia Open Records Act, OCGA, Section 50-18-70, and that she was requesting the records in the standard machine-readable format within 3 business days. Rudd said that internal docket routing notations were administrative working documents and might be subject to an exemption review. Simone said she understood that exemptions existed and that she would appreciate a written determination of which specific exemption applied to each withheld document, as required under OCGA, Section 50-18-71, within the 3-day response period. Rudd took off her glasses. She set them on the chain. She looked at Simone with an expression that had moved past the reassessment of their first exchange and arrived somewhere closer to recognition. The recognition of someone who understands, for the first time, that the person across the counter has been preparing for this moment. She said she would process the request. Simone thanked her and walked away from the window. She did not look back to see if Rudd watched her go. She knew she did. The second day of the 48-hour period, the morning of the hearing, was when the escalation entered its next register. Simone arrived at 7:15 a.m. Breck was at the security station. He had the clipboard. He had the list. He ran his finger down it in the same manner as before, and this time his finger did not stop at her name. Instead, he looked up and said, "Access has been suspended pending the hearing outcome today." Simone asked for the written order authorizing the suspension. Breck said he had been informed by the administrative office. She asked whether the administrative office had provided a written order. He said he had verbal instruction. She said that under the courthouse access policy, Administrative Order 2019-04, the same order she had cited on her first day, access could be restricted only by written judicial order, administrative determination with documented basis, or active law enforcement action, and that a verbal instruction from the administrative office did not constitute any of those 3 categories. Breck said she needed to step aside. She did not step aside. She stood exactly where she was, not in his path, not in the path of anyone behind her, but at the threshold, which was the relevant location. She said, at the ordinary conversational volume she always used, "Deputy Breck, I am requesting written documentation of this access suspension. I am not resisting. I am standing still." What happened next was not ambiguous, though it would later be described in 3 different ways by 3 different people, none of whom were standing exactly where Simone was standing. Breck moved around the counter. He put his hand on her arm, not a grab but a grip, not a push, but the kind of contact that has a direction embedded in it. He said she needed to come with him. A young clerk near the elevator door went still. Simone said, at the same volume as before, "I want it on record that I am not resisting this contact. Deputy Breck has placed his hand on my arm without a written order." The time is 7:19 a.m. The hallway had an audio pickup near the entrance. It was part of the courthouse security system, installed under a bond measure 3 years prior and maintained by the county IT department. Its footage retention period was 30 days. Simone had confirmed the retention policy 6 weeks earlier through a records request she had submitted under a slightly different spelling of her name. Not a false identity, but a variation she was legally entitled to use, one that appeared in no document filed in Caldwell County. The audio was recording. Breck walked her to a room off the main corridor, on the ground floor, labeled Administrative Holding, Security Review. It was a beige room with a table, 4 chairs, a water cooler that was not running, and a wall clock. There was no window. There was a camera in the upper left corner of the ceiling. The camera's red indicator light was on. Breck told her to wait. He left. The door did not lock. She tested it within 30 seconds of being alone, not by turning the handle, but by pressing her fingers against the edge, feeling for the magnetic catch. It was not engaged. She was not under arrest. She was being held in a beige room on verbal instruction from the administrative office, which was not a lawful basis for detention under any applicable Georgia statute she was aware of. And she was aware of quite a few. She sat down at the table. She placed the accordion folder in front of her, flat. She opened the section tabbed with the orange divider and removed the most recent set of documents. She began to read. She had been reading for approximately 18 minutes when the door opened. It was not Breck. It was a man she had not seen inside this courthouse before. Mid-40s, a dark jacket, a badge clipped to his belt that she registered without visibly registering. He closed the door behind him. He sat down across the table. He set a manila sleeve on the table between them, not sliding it toward her, just placing it in the space between them, as one might place an object in the center of a shared workspace. He said, "Good morning." She said, "Good morning." He said his name was Micah Dove. He said he was following up on a filing. She said she was glad he was there. He looked at her for a moment with the assessment of someone determining whether the situation is what it appears to be, and then he nodded, once, the way people nod when a calculation comes out right, and he said, "Miss Voss, how are you holding up?" Not ma'am, not miss, not the woman in question, or the individual, or any of the other anonymous constructions that had been used in this courthouse for the past 4 months. Miss Voss, as if he had been saying her name correctly for quite some time, as if he knew it well. She said she was holding up fine. He pushed the manila sleeve an inch toward her. She looked at it. She did not open it. He said he wanted to make sure she had everything she needed for the hearing in approximately, he checked his watch, 41 minutes. She said she had what she needed. He said he would see her upstairs, and he stood, and he straightened his jacket, and he left the room. The door was still not locked. She was no longer required to be there. She knew this not because anyone had told her so, but because the dynamic in the room had shifted the moment Micah Dove had closed the door behind him. And the dynamic of a room tells you more than the lock on its door. She waited 4 more minutes. She placed the manila sleeve inside the accordion folder without opening it. Then she stood, picked up the folder, and walked out of the room and down the corridor, and into the elevator, and up to the second floor, where the gallery doors for courtroom 3 were just opening for the hearing that Carter Pell had filed 48 hours earlier, and that Judge Carla Weiss was about to preside over with the settled certainty of someone who has held the room for 17 years and expects to hold it for 17 more. The gallery filled. Caleb was at the counsel table. Pell was at the opposing table, his suit impeccable, his file arranged with the neat aggression of someone who expects to win. Simone took a seat in the second row. She placed the accordion folder on her lap. She opened it to the orange tabs section and removed a single sheet, a copy of the local rule, the one with the court administrator's seal and the current version date, the one that said 10 days, not 15. She placed it face down on her knee. She waited. Weiss entered at 10:03 a.m. She sat. She called the case. She looked at the room, at Pell, at Caleb, at Simone, and her gaze settled on Simone for slightly longer than the room required, which was noted and written down in the notebook that was already open on the bench beside the accordion folder. Then Weiss said, addressing the gallery, "I understand there is an individual present who has been the subject of today's motion. For the record, I want to make clear that while the gallery is a public space, this proceeding concerns the conduct standards applicable to that space, and I will be attentive to conduct throughout." Simone said nothing. She kept her eyes on the bench. She turned the sheet on her knee so the text faced upward and placed her hand flat on top of it. Pell stood and began to speak. Outside in the corridor, 50 feet from the courtroom door, Deputy Floyd Breck stood with his arms crossed and an incident report form on the wall-mounted clipboard beside the security station. He had begun filling it out approximately 40 minutes earlier, while Simone was in the administrative holding room. He had been filling it out slowly, adding a phrase, pausing, adding another, with the focused concentration of someone composing something they want to get right. The incident report would state that Simone had raised her voice during the earlier hearing. It would state that she had approached the bench in a manner that required the presence of court security. Neither statement was accurate. Breck knew this. He was not a person who did not know the difference between what had happened and what he was writing. He was a person who had made a calculation about which version of events was safer for him to have on paper, and he was writing that version. What Breck did not know, what no one in that corridor, in that courtroom, in that building had yet been told, was that he had been speaking out loud while composing his report. Not loudly, not consciously, the way people sometimes mutter or voice their thoughts while writing, the way people do when they believe they are alone. The vestibule audio system had a reach of approximately 40 feet in the main corridor. Breck's security station was 32 feet from the nearest audio pickup. Its footage retention period was 30 days. The recording was already running. It had been running all morning. Pell's motion ran for 40 minutes and arrived at a recommendation that the court issue a standing order prohibiting non-attorney, non-party gallery observers from taking notes, communicating with counsel, or making any verbal statements during proceedings, with violations subject to contempt citation. He cited 3 Georgia decisions in support. He cited the unauthorized practice statute twice. He was organized, fluent, and entirely confident of the outcome. Caleb offered a brief opposing argument, noting that the proposed order would effectively restrict constitutionally protected court attendance rights, and citing Richmond Newspapers, Inc. versus Virginia, a United States Supreme Court decision affirming the First Amendment right of public access to judicial proceedings. Pell objected that the federal precedent was inapplicable to state court gallery conduct standards. Weiss said, "Objection noted," without ruling on it, and thanked both attorneys. Then she looked at Simone. "You've been in this gallery for several hearings," Weiss said. "Would you like to say anything before I rule?" It was an unusual invitation. Not unprecedented, judges could solicit input from gallery observers in administrative matters directly affecting them. But unusual, and its timing told Simone something. Weiss wanted something on the record before she ruled, either a statement she could use to support the order or a silence she could characterize as acquiescence. Simone stood. She held the single sheet, the one with the administrator's seal and the current version date, and she said in the voice she used for all of this, the voice that was neither too quiet nor too present, "Your Honor, before the court rules, I'd like to note for the record that the local rule cited by the court at the hearing on Thursday, Local Rule 4.3, specifying a 15-day advance submission requirement, appears to differ from the current published version of that rule, which specifies 10 days. I have a copy of the current version here with the court administrator's seal. I'm making this note for the record, not as argument." She held up the sheet. She did not approach the bench. She did not take a step. She stood in the second row and held the sheet so the seal was visible and the date at the top was visible, and she waited. The courtroom was quiet. Weiss looked at the sheet from the bench. She looked at it the way someone looks at a thing they had expected to stay put that has moved. She did not respond immediately. She turned to the clerk. She said at a lower register than her bench voice, "Pull the current version of 4.3. The clerk left the room. Pell straightened in his chair. Caleb wrote something in his file. Nobody spoke for 3 minutes and 40 seconds. The clock on the courtroom wall was audible. The gallery, which had been approximately half full at the start of the hearing, was entirely still. Then the clerk returned and placed a document on the bench. Weiss read it. She did not show what was on her face. Whatever it was, she reassembled it quickly. She said, to no one in particular, "This will be reviewed." She set the document aside. She ruled on Pell's motion, granting a modified version that restricted gallery members from communicating verbally with counsel during proceedings and required advanced submission of any written materials they wished counsel to review, but that preserved the right to attend and to take notes, which was the core right Pell had been trying to eliminate. It was a partial victory for Pell, partial for Caleb, and in the specific arithmetic of this courtroom, a significant moment for the woman in the second row who had just put a document with a court administrator's seal on the record without standing up, without raising her voice, and without a single word of argument. Weiss adjourned the hearing. She gathered her materials. She walked to the door behind the bench. She paused, with her hand on the door, and looked at the gallery once more. Not at the room in general, but at the second row specifically. She did not say anything. She left. Simone sat for another 2 minutes after the room cleared. She opened the notebook. She wrote the time, 11:27 a.m. She wrote what had been said. She wrote what had been ruled. She wrote, "Rule confirmed 10 days. Bench citation incorrect, on record." She underlined the last 2 words. Then she placed the document back in the red tab section of the accordion folder, behind the photograph from the law library, and beside the index card that said, in her handwriting, Weiss. Outside the courtroom in the corridor, Breck was still at his station. He saw her come out. His expression did not change. He looked at her the way he had looked at her every day she had come to this courthouse, with the settled hostility of a man who believed, until recently, that the contest was already over and he had already won. She walked past him. She did not look at him. She pressed the elevator button. She waited. The door opened. She stepped inside. Behind her, still at his station, Breck looked down at the incident report form. He looked at it for a long time. Then he folded it, once, and put it in the breast pocket of his uniform. He would finish it later, he told himself. He would finish it where there was less chance of being interrupted. He did not know about the audio pickup. He did not know about the 30-day retention. He did not know that 40 feet was a shorter distance than he thought. The elevator doors closed behind Simone Voss. The fluorescent light in the lobby flickered. It held. It flickered again. And somewhere, in a state agency building 30 minutes north on the state highway, in an office that did not advertise its function, a file labeled JQC 2024-0047 was being updated with a new entry dated that morning. The entry noted, in the sparse language of administrative documentation, that Phase 2 of the field observation had concluded and that the evidentiary record was being prepared for review. The name of the lead investigator on the file was not visible in the lobby. It was not visible in the courtroom. It was not visible in the accordion folder that rode up in the elevator beside a woman in an unremarkable coat with a notebook nearly full of dates and weather and names. It was visible only in the blue tab section, which had not been opened in 11 months. Not yet. The incident report that Floyd Breck submitted 2 days later was 4 paragraphs long. It stated that on the morning in question, the subject, identified as V.S., non-attorney gallery observer, had raised her voice in the main corridor, had made physical contact with the security station counter in a manner that impeded officer function, and had required verbal redirection on 3 separate occasions before complying with administrative instruction. The report listed the time of the incident as 7:31 a.m. and described the subject's demeanor as agitated and uncooperative. None of it matched what the audio pickup had recorded. The vestibule recording, pulled from the courthouse security server 11 days after the incident by an IT administrator responding to a formal records request filed under a case reference number that appeared nowhere in the Caldwell County docket system, captured 14 minutes and 22 seconds of audio beginning at 7:16 a.m. It captured Simone stating her name and the policy citation at a conversational volume. It captured Breck's instruction to step aside. It captured Simone's clear, measured statement, "Deputy Breck, I am requesting written documentation of this access suspension. I am not resisting, I am standing still," followed by the sound of movement that preceded her being walked to the administrative holding room. It captured nothing that resembled a raised voice, nothing that resembled contact with the counter, and nothing that required 3 instances of verbal redirection. It also captured something else. Approximately 9 minutes into the recording, after Simone had been walked to the holding room and the corridor had gone quiet, it captured a man's voice, close to the security station, speaking in the low and distracted register of someone who believes he is alone. The voice described what had happened. It described it in abbreviated, fragmented language, the kind used when composing rather than conversing. Short phrases, revisions, self-corrections. She raised her voice and, make it raised her voice. A pause. Approach the bench. No, approach the counter, the station. Another pause. Typing sounds, or the sound of pen on paper. Uncooperative, yeah. A long exhale. 3 times, 3 verbal redirections. The audio ran for another 4 minutes and 16 seconds after that. Nothing further of evidentiary note. Then a door, footsteps, silence. Micah Dove had submitted the audio log to the Georgia Judicial Qualifications Commission pre-hearing panel on the same Tuesday that Pell's motion was being argued in Courtroom 3. He had not been in that courtroom. He had been in a conference room in a state administrative building 12 miles from the Caldwell County line, seated across a table from a 3-member review panel, reading the log aloud from a printed transcript. The transcript entry for the self-dictated report portion read as follows, in the sparse format of official documentation. Recording timestamp 07:25 a.m., April 9th. Badge number 447, Deputy Floyd Breck. Case reference JQC 2024-0047. Duration of relevant segment, 4 minutes, 11 seconds. Transcribed content, subject to full audio review, as follows. And then, word for word, what Breck had said to himself in the corridor while believing no one could hear him. Breck's union attorney, seated at the end of the table, had objected to the admissibility of the recording on the grounds that the subject had not been informed he was being recorded in a law enforcement setting. The panel chair had noted the objection for the record and had pointed out, in the even tone of someone who has spent considerable time reading statutes, that the audio system in question was a publicly disclosed courthouse security system operating in a non-restricted common area, that its existence and recording function had been posted on a placard near the main entrance since its installation 3 years prior, and that Georgia law governing two-party consent, OCGA Section 16-11-62, applied to private communications and not to statements made in a public institutional setting covered by a disclosed recording system. The objection was overruled. Breck had been placed on administrative leave by the end of that day. Not fired. That would take considerably longer, and the outcome was not yet certain. Suspended without pay pending the investigation's findings. His attorney immediately filed for reinstatement pending the disciplinary hearing, which was his right under the county's collective bargaining agreement with the courthouse security union. The reinstatement request was being reviewed. The review would take weeks. Simone learned about the administrative leave not through any official notification, but through the courthouse itself, which operated like all institutions of its size, meaning that personnel changes became known to regular visitors before they were announced. She arrived at 7:15 a.m. on the Thursday of that week and found a different officer at the security station. She logged the change in the notebook without comment. She did not celebrate. She noted it as a development, wrote the date, and proceeded to the elevator. What she was focused on that Thursday was not Breck. Breck was a piece of the record, an important piece, the piece that most clearly illustrated the pattern of physical pressure used to manage unwanted presence in the building. But he was not the center. The center was the courtroom itself. The center was the 17 years of signed orders, misquoted rules, denied motions, and manipulated continuances that sat in the case files of Caldwell County Superior Court like sediment. Invisible if you were looking at any single case, unmistakable if you laid them side by side and measured the distance between what the law said and what the judge had done. That measurement was the work Simone had been doing for 11 months. Not just Darnell's case, all of them. The open records request she had filed the previous month, the one for full docket routing notations across Darnell's case history, had produced a response that was, in its own way, more revealing than a direct answer would have been. The response arrived in a padded envelope, 42 pages of docket records with 17 entries redacted in full and 2 entries partially redacted, each redaction accompanied by the same single-line justification. Administrative working document, deliberative process exemption. The deliberative process exemption under Georgia law was real and legitimately applied in certain contexts. It was not, however, applicable to ministerial records of routine docket routing actions, which are procedural rather than deliberative in nature. That distinction was established in case law Simone had confirmed through a law library search before the records arrived. She forwarded the response along with a 3-page legal analysis of the inapplicable exemption to Darnell Voss at the Georgia Attorney General's Civil Rights Division. Voss had been on the case since month 7. She was not a dramatic figure. She was a staff attorney who worked in precise, methodical increments and communicated in bullet points. But she was the person whose office had the authority to compel production of the redacted records if the exemption challenge was sustained, and she had been building that challenge quietly and in parallel with everything Simone was accumulating in Caldwell County. Voss responded to the forwarded records with 4 words in the subject line. This completes the predicate. She meant the evidentiary predicate for the formal referral. She meant they had enough. The formal referral from the Georgia Attorney General's Civil Rights Division to the Judicial Qualifications Commission was filed on a Friday afternoon under case reference JQC 2024-0047, the same number that had been on Micah Dubb's badge the morning he sat across from Simone in the administrative holding room, the same number that had appeared in the file update on the day of Pell's motion hearing, the same number that had been attached to the audio recording pulled from the courthouse security server. The referral had been building for 11 months. It had been waiting for the last piece, which was the docket records. Not because the other evidence was insufficient, but because the docket records made the pattern undeniable across multiple cases, not just one. A pattern was harder to attribute to judicial discretion. A pattern looked like what it was. The referral cited 9 cases spanning 4 years. It cited Darnell Voss's property dispute as case number 1, the case through which the investigation had been initiated after an external complaint. It cited 6 other civil cases involving Black and low-income litigants, in which continuances had been entered without the written findings required under Georgia Rule of Uniform Superior Court Practice Rule 10.1. It cited 2 cases in which Local Rule 4.3 had been cited from the bench in a manner inconsistent with the current published text. It cited Ivory Rudd's routing pattern, 7 filings rerouted to inactive queues across 3 cases, documented through the county IT administrator's log and the open records response. It cited the county newsletter photograph, the fundraiser date, and the continuance date, which appeared as a 3-item timeline in Exhibit F. It did not cite Raymond Chalk by name in the body of the referral. His name appeared in a footnote attached to Exhibit F, preceded by the phrase, "The Commission's attention is directed to the following potentially relevant correspondence." The correspondence was the subpoenaed email thread. The subject line, "The Voss situation," was legible. The body remained partially redacted pending a privilege review that Chalk's attorney had requested on the grounds of official communications exemption. The privilege review was ongoing. The redacted section stayed redacted, and what was underneath it was not yet known to anyone outside the privilege review panel. The JQC hearing was scheduled for a Wednesday in the 3rd week of April. It was not held in Caldwell County. It was held in the Commission's administrative hearing room in Atlanta, a room with no gallery and a formal record that would become a public document once the preliminary findings were issued. Simone drove north on the state highway on Tuesday evening. She did not stay in Caldwell County. She arrived at the hearing room at 8:45 a.m. She set the accordion folder on the table beside her seat. She opened it to the blue tab section for the first time in the presence of other people. She removed a credential card and a bound case summary and placed them in front of her on the table. The credential read, "Supervising Appellate Counsel, Georgia Supreme Court Office of Special Investigations." The case summary bore the number JQC 2024-0047 and a date range spanning 11 months. Micah Dove was already seated at the adjacent table. He had a matching copy of the case summary. He did not look surprised to see her with the blue section open, because he had known what was in it since month 3 of the investigation, when the Supreme Court's Office of Special Investigations had formally assigned her to the field component, and he had been designated as the JQC's coordinating investigator. What he had not told her, and what she had not asked him to tell her, was the identity of the person who had filed the original external complaint that triggered the investigation in the first place. She had her suspicions. She kept them in the notebook, on the last page, under no heading at all. Just a name, not confirmed, not acted upon, set aside for after. The hearing panel consisted of 3 commission members, a retired appellate judge, a practicing attorney in good standing, and a law school dean. The panel chair read the case reference into the record. She read Simone's designation into the record. The room was quiet in the way that rooms are quiet when the people in them understand the weight of what is about to happen and have collectively decided to let the documents speak. Dove presented the audio recording log first. He read the transcript of Breck's self-dictated incident report into the record, in full, including the pauses and the self-corrections, the way you read something that is most damaging when heard exactly as it occurred. The panel chair made a notation. The union attorney, seated at the back of the room, made 2 objections. Both were overruled on the grounds already established at the pre-hearing. Then Dove presented the docket routing analysis. He read the 7-case routing log from the IT administrator's documented report, each case number, each filing date, each routing designation, each date on which the filing had been redirected from the active docket to the inactive review queue, and the total number of days each filing had sat in that queue before being returned, or, in 3 instances, before it had been returned at all. The average delay across the 7 filings was 41 days. The longest single delay was 73 days. In a case involving a custody modification petition filed by a Black single father who had ultimately missed the statutory response window and had his petition dismissed for failure to prosecute. The panel chair asked Dove whether the routing decisions had been made by a single administrator. Dove said the log showed a single user ID associated with all 7 routing actions. The user ID belonged to Ivory Rudd. The panel chair made another notation. She asked whether the routing actions were within the scope of Rudd's administrative authority. Dove said that standard routing authority extended to transferring filings between active dockets for scheduling purposes, but did not extend to transferring filings to inactive review status without a judicial instruction on record. He noted that none of the 7 routing actions had a corresponding judicial instruction attached. The next document was the Local Rule 4.3 comparison. Dove placed 2 copies side by side on the record, the text as cited by Judge Weiss on 2 occasions, and the text as it appeared in the current published version. The discrepancy was 12 words. Those 12 words were the difference between a 10-day and a 15-day submission requirement. And across the 2 cases where the incorrect version had been cited, a total of 4 motions had been denied on timeliness grounds using the incorrect standard. Dove identified each of the 4 motions, each of the litigants, and each of the outcomes. In 2 of the 4 cases, the denial had been outcome determinative, meaning the motion had been the primary vehicle for relief, and its denial had effectively ended the litigant's ability to pursue their claim. He read the county newsletter photograph's caption into the record: date of the fundraiser dinner, names of the attendees, the title line. He read the case number and the date of the continuance entered 2 days after the dinner. He read the continuance order itself, 4 lines, no findings, signed by Judge Carla Weiss. He asked the panel to note that the required written findings under Rule 10.1 were absent. The panel chair said it was noted. It was at this point in the hearing, 47 minutes in, with the 3rd exhibit binder still open and 2 more on the table, that the door at the back of the hearing room opened. The man who entered was in his early 70s, with silver hair worn close at the temples, and the particular stillness of someone who has spent decades in rooms where stillness is itself a form of authority. He wore no robe. The hearing room was not a courtroom, but the commission members recognized him immediately, and the recognition shifted something in the room's atmosphere in the way that a change in air pressure shifts the expectation of weather. He took a seat at the back without announcing himself, without ceremony, the way a person sits down who does not need ceremony to be seen. Micah Dove did not stop his presentation. He continued to the next exhibit. Simone did not turn around. She had known he would be there. That had been arranged, and the arrangement had been part of the plan, and the plan had been 11 months in the making. But knowing something is coming and sitting in the room when it arrives are different experiences, and she took 1 breath, measured, the way she had been taking measured breaths in this courthouse since the first day Breck pointed her toward the wooden bench. And she kept her hands flat on the table and listened to Dove read from the next document. When Dove finished the presentation of exhibits, the panel chair asked him whether the investigation had produced any evidence of coordination between Judge Weiss and other county officials that had materially affected the conduct of proceedings. Dove said that the investigation had produced 1 item of potential relevance: a subpoenaed email thread that remained partially redacted pending privilege review, and that the commission would be notified when the review concluded. He said that in the interim, the documented record was sufficient to establish the predicate findings under Georgia Code of Judicial Conduct Canon 2 and Canon 3, and to support a formal complaint and recommended recusal pending the Commission's full disciplinary proceeding. The panel chair asked Simone whether she had anything to add to the formal record before the panel moved to preliminary findings. Simone looked at the notebook, which was open on the table beside the credential card and the case summary. She had written in it this morning, before driving to Atlanta, the date, the weather, a single line. She closed it. She said, "The record speaks. I have nothing to add." The panel chair thanked her. She turned to the man at the back of the room. He introduced himself for the record as Jasper Holt, Chief Justice of the Georgia Supreme Court. He said he was present in his capacity as the supervising authority over the Office of Special Investigations, and that he wished to note for the Commission's record that the investigation referenced in case JQC 2024-0047 had been conducted in accordance with the procedures and authorization of that office, that the lead investigator had operated with full institutional authority throughout the field observation period, and that the evidentiary record before the panel had been assembled and maintained in compliance with all applicable chain of custody requirements. He said one more thing. He said it without elaboration, in the same even register in which everything else in that room had been said. He said, "Ms. Voss conducted this investigation with exceptional procedural integrity under conditions that would have tested most experienced practitioners. The Commission should know that." He said nothing further. He did not need to. The preliminary findings were issued 11 days later. Judge Carla Weiss was recused from all pending cases in Caldwell County Superior Court, effective immediately, pending the full disciplinary proceeding before the Judicial Qualifications Commission. The proceeding was expected to take 6 to 18 months. No determination of removal had been made. The Commission did not make findings of removal at the preliminary stage. What it made was a referral to the full panel and a recommendation of interim recusal, which carried the force of a judicial order and which Judge Weiss could not refuse without triggering an automatic escalation to the Georgia Supreme Court. She did not refuse it. Floyd Breck's administrative leave was extended pending the outcome of 2 parallel proceedings. The Internal Affairs Disciplinary Hearing under OCGA Section 45-11-4, which was expected to take 4 to 6 months, and a civil rights action filed in the United States District Court for the Middle District of Georgia under 42 U.S.C. Section 1983. The civil action had been filed by a civil rights organization that had been monitoring the case, not the one Simone worked for, but one that had been notified through the AG's office as the referral moved forward. The U.S. Attorney's Office had also received the audio transcript, the incident report, and Dove's comparison of the two. Whether that would produce a referral under 18 U.S.C. Section 242, the federal criminal statute for deprivation of rights under color of law, had not yet been determined. The phrase used in the U.S. Attorney's written acknowledgement was, "under active review." Ivory Rudd was placed on administrative leave by the county clerk's office the day after the JQC preliminary findings were released. The records tampering review opened by the DA's office was assigned to a special prosecutor from outside Caldwell County, given the potential conflict of interest involved in the local DA's office reviewing conduct that had occurred under the oversight of a DA whose office had filed motions in front of the same judge. The special prosecutor's first action was to subpoena the full routing log and the IT administrator's access records going back 5 years. Carter Pell received a written reprimand from the State Bar of Georgia, issued through the bar's Client Assistance Program following a complaint filed by Caleb on behalf of Darnell Voss. The reprimand cited the exclusion motion as an instance of filing a pleading for an improper purpose, specifically using a procedural motion as a mechanism to restrict constitutionally protected court access rather than to address a legitimate legal question. The reprimand was not the most severe sanction available. It was the first step in a graduated disciplinary process that could escalate if additional conduct came to light. Pell had retained private counsel. He had not yet commented publicly. Raymond Chalk's situation was the least resolved, and in the specific arithmetic of institutional accountability, the most uncertain. The County Ethics Board referral was active. The email thread remained partially redacted. His attorney had filed a motion to quash the subpoena for the full thread on grounds that extended the privilege review argument into new procedural territory, and the motion was pending before a Superior Court judge from an adjacent county who had been designated to handle the matter precisely because every judge in Caldwell County had either a potential conflict of interest or an association with the original proceeding. The motion would take months to resolve. The redacted section of the email, whatever was underneath the black bars, would not be known to the public until the review concluded, and either the privilege was sustained or it was not. Darnell's case was transferred to a newly assigned judge from outside Caldwell County within 72 hours of the recusal order. An emergency review of the prior continuances was granted. The hearing on the renewed motion for relief, the motion that Caleb had been trying to get heard for the better part of a year, was scheduled for the second week of May, approximately 5 weeks away. Whether the case would be resolved in Darnell's favor was not yet determined. That depended on the merits, and the merits would be evaluated by a judge who had not spent 17 years shaping the outcomes of cases in Caldwell County. That was all Darnell had asked for. A judge who would read the file without having decided the answer first. Simone drove back to Caldwell County the evening after the JQC hearing. Not because she needed to. The field observation was concluded, and there was no procedural reason for her to return. She drove back because her brother lived there. Because the property with the disputed fence line was still there. Because the ordinary life that this courthouse had been complicating for 2 years and 4 months was still being lived by a person who had not chosen to be part of any of this except in the most basic sense, the sense that he had filed a legal claim and expected it to be heard. She knocked on his door. He opened it. She said his name. He said hers. Neither of them said anything for a moment. He stepped aside to let her in, and she came in, and she set the accordion folder on the kitchen table, and she sat down. He made coffee. She did not open the folder. They sat at the table and drank the coffee and talked about things that had nothing to do with courts or case numbers or 17-year judges or audio recordings or anything in the accordion folder. And the kitchen was quiet, and the evening came in through the window above the sink. And outside, the disputed fence line was still where it was, but for the first time in 4 months, it was someone else's job to resolve it. Simone drove home the following morning. She stopped once, on the state highway, at a gas station she had used every few weeks for the past 11 months. She filled the tank. She went inside and bought a bottle of water and a notebook, the same kind she always bought, ordinary, sold in bulk. She paid. She got back in the car. She put the new notebook in the outer pocket of her shoulder bag, and the old one, nearly full, in the glove compartment. She still had the accordion folder. The blue tabs section was still in it, because it belonged to her and had always belonged to her, and would be filed in the proper place when the time came. The red tab section was still in it too. Every photograph, every index card, every document with a court administrator's seal. Those would go to Dove's case file, properly logged, within the week. The orange tab section, and the green, and all the others, those she would review at her desk, one by one, at the pace that thorough review required. At the Georgia Attorney General's office in Atlanta, 3 days after the preliminary findings were issued, a staff clerk in the Civil Rights Division received a padded envelope in the morning mail. It was addressed to the division, no specific recipient. The postmark was Caldwell County. There was no return address. Inside was a USB drive and a single sheet of paper with one typed line. 8 words. She wasn't the only one. The clerk set the envelope on the desk of Dahlia Voss. Voss read the typed line. She read it again. She set it down and looked at the window for a long moment. The way someone looks when they have been doing this work long enough to know that closed cases rarely stay fully closed, and that the quiet after a preliminary finding is not the quiet of resolution, but the quiet of the next thing gathering itself in the distance. Unhurried and patient, the way all of this had been unhurried and patient from the beginning. She picked up the USB drive. She put it in a labeled evidence envelope. She wrote the date on the outside. She wrote the case reference number, JQC 2024-0047, and then below it, a new number, JQC 2025-0003. The file was open before anyone had decided to open it. That was how these things worked, when they worked at all. Slowly, and with documentation, and without the kind of dramatic announcement that suggests the system has suddenly decided to fix itself overnight. The system had not fixed itself. One judge had been recused. One deputy was on leave. One administrator was under review. The email thread was still redacted. The USB drive was in a labeled envelope on a desk in Atlanta. The 10 minutes of missing body cam footage, the gap in the recording from the day of Simone's detention in the administrative holding room, the gap the department had attributed to equipment malfunction, in which the IA report had noted without resolving, that was still missing. It stayed missing. Some things in the accounting of institutional accountability get resolved in the first pass. Some get resolved in the second, and some sit in labeled envelopes and unresolved footnotes and partially redacted email threads, waiting for the next person who shows up at 7:15 a.m. with an accordion folder and a notebook, and the particular kind of patience that looks, to people who don't understand it, like acceptance. It has never been acceptance. It has always been preparation. There is a version of this story that ends with a single dramatic moment, a door opening, a title revealed, a room going silent. And that moment matters, but it is not the lesson. The lesson is the 11 months before it, the spiral notebook, the laminated card, the open records request filed on a Tuesday for a form that was temporarily out of stock, the measured breath at a security threshold where someone with a clipboard decided, for reasons he never had to explain, that she did not belong. Simone Voss did not win because she was extraordinary. She won because she was prepared and patient, and she wrote everything down, every name, every date, every deviation from the rule as written. She understood that accountability does not arrive like a verdict, sudden, final, clean. It arrives the way sediment moves, slowly, invisibly, until one morning the weight of it shifts everything. The systems that failed Darnell Voss had been failing people for years before he filed his claim. They will require years more of this kind of work to fully answer for it. That work belongs to all of us. If this story stayed with you, share it, subscribe, because the next one is already being written.